We address you today, 21st of April, 2026. And the topic for this interface is called the anatomy of a conspiracy. The MPP Minority Caucus is engaging the media not merely to contest a High Court ruling. We do this to expose in the full light of public scrutiny a deliberate, coordinated, and sustained campaign by the NDC government to suffocate, neutralize, and ultimately destroy the office of the Special Prosecutor, the institution that was created by Parliament to prosecute corruption and corruption-related cases free from executive interference. What happened on 15th April 2026 at the High Court in Accra was not a spontaneous act of judicial reasoning. It was the latest maneuver in a campaign that stretches back to the very day the OSP dared to lay its hands on an individual whom the NDC considers its own. Now, to understand what is happening today, one must understand what has been happening since December 2025. The dots, when well connected, form a picture that should disturb every Ghanaian who cares about accountability, the rule of law, and the integrity of our constitutional order. Now the trigger. The story of the NDC's war on the OSP began on 3rd December 2025. On that day, private legal practitioner Martin Kpebus, a man who had launched a sustained public campaign against the Special Prosecutor Kisie Jabeng, accusing him of incompetence and calling for his removal. He arrived at the OSP's offices in response to an invitation to assist with an investigation. The visit soon degenerated into a verbal confrontation between Martin Kpebus and the military officer at the premises. Mr. Kpebus was subsequently detained for approximately 5 hours and held at a BNI facility before being released on bail. Subsequently, and within days, Mr. Kpebus announced his intention to petition President Mahama for the removal of the Special Prosecutor. He explicitly named the detention as his grounds, and the NDC government moved with remarkable speed to respond. The opportunity to strike had been discovered by the government. The NDC government identified its man, its moment, and its method. All these three converged in December 2025. The minority further notes for the public record who Martin Kpebus is within the spheres of the NDC. He is not a neutral commentator. He is a man who, upon the High Court's ruling on 15th April 2026, stripping the OSP of its powers, publicly stated that the ruling was, quote, sweet, end quote. A man whose petitions, media campaigns, and legal commentary had consistently served to weaken, discredit, and delegitimize the OSP office. And the NDC decided the OSP had to be destroyed. Now, the first weapon. On 8th December 2025, exactly 5 days after Mr. Kpebus' detention, the majority leader, Honorable Mahama Yariga, and the majority chief whip, Honorable Roxanne Nelson Dafia-Mekpo, laid the office of the Special Prosecutor Repeal Bill 2025 before Parliament through a private member's bill. The bill proposed one thing: the total abolition of the OSP. It sought to repeal the Act 959 in its entirety, dissolve the office to transfer all prosecutorial authority to the Attorney General's Department, and absorb staff into the AG's office. The stated reasons: duplication of functions, institutional friction, high cost relative to impacts, were thin pretexts. The real reason had walked out of the BNI detention facility 5 days prior. The public reaction was swift and fierce. Civil society organizations, legal experts, and governance institutions condemned the bill. Transparency International Ghana rejected the move as unnecessary and premature, and it warned that the OSP required time and institutional space to fulfill its mandate. Legal practitioners pointed out the obvious, that politically exposed persons were leading the charge to scrap the very institution that statutory authority has to investigate them. Even within the NDC itself, the bill caused deep consternation and visible embarrassment. The NDC General Secretary, Fifi Kwete, publicly criticized Honorable Ayariga and Honorable Dafia Mekpo for acting without consulting party leadership, warning that unilateral action risked embarrassing President Mahama. President Mahama was forced into the uncomfortable position of publicly distancing himself from his own majority leadership. On 10th December 2025, addressing the National Peace Council, President Mahama described calls for the scrap of the OSP as, quotes, premature, end quotes. Praised the office as the only anti-corruption agency with full prosecutorial independence, and said, and I quote again, "The unique thing about that office is that it is the only anti-corruption agency that has prosecutorial powers to prosecute cases itself without going through the Attorney General," end quotes. On 11th December 2025, the presidency announced that President Mahama had directed the withdrawal of the bill. They simply found another way. Now, this is the second weapon. When the petitions came flying, ladies and gentlemen of the media, by President Mahama's own accounts, 3 formal petitions against Mr. Kissie Jaben were submitted to President Mahama. Martin Kpebus himself disclosed to the media that the true number was as high as 15. Now, when was the last time in the history of Ghana's Fourth Republic that 15 petitions were filed against any individual, any public office holder under Article 146? The answer is 0. The grounds cited were a catalogue of grievances: incompetence, abuse of office, cronyism. One petition was filed by a database administrator at the Electoral Commission, who was at the time himself under interdiction. A detail that speaks to the quality of the petitioners and the seriousness of their complaints. The petitions were coordinated, themed, and timed to create the impression of overwhelming public dissatisfaction with an institution that was, in truth, doing exactly what it was created to do: to investigate the politically connected without fear or favor. President Mahama referred the petitions to the Chief Justice Paul Bafoboni on 25th November 2025, and on 26th January 2026, the Chief Justice responded with unmistakable clarity. Not a single petition established a prima facie case against the special prosecutor. Not one. 3 referred formally to the Chief Justice, 0 prima facie case established. The petitions were not serious legal instruments. They were political weapons designed to harass, delegitimize, and remove from office a public servant whose crime was that he was doing his job. When the petitions failed, the NDC needed a third weapon: the Supreme Court. On 12 December 2025, The very day MPP minority was demanding the resignation of Honorable Ayariga and Honorable Dafiamekpa for the repeal bill debacle, a private legal practitioner named Noah Ephraim Tete Adamti filed a suit at the Supreme Court, registered as suit number J1/3/2026, seeking a declaration that the OSP's Office of Prosecutorial Powers is unconstitutional. I take that again. That the OSP's exercise of prosecutorial powers is unconstitutional. The minority asked a simple question that every Ghanaian deserves to have answered. Is the timing of this filing on the same day the legislative effort to kill the OSP bill collapsed in public embarrassment a coincidence? We do not believe it is. We believe it is the calculated continuation of the same campaign by different means. When you cannot kill an institution by statute, you attempt to do so through constitutional litigation. What followed confirmed our worst fear. The Honorable Attorney General did not defend the state's own institution. He joined the assaults on the state institution. On 8th April 2026, the AG filed submissions at the Supreme Court siding substantially with the plaintiff and argued that Parliament acted unconstitutionally when it passed Act 959, and praying the Supreme Court to declare the independent prosecutorial provisions of the Act void. And this is one situation where the defendant and the plaintiff are the same. And in musical parlance, we say, I and my shorty are one. Let the significance of this be appreciated in full. The Attorney General is the defendant in Adamte and Attorney General. He was served as a party expected to defend the state's legal framework. Instead, and sadly so, the Attorney General turned his weapon on his own client, the Republic of Ghana, and became an auxiliary plaintiff. The state's chief legal officer is now arguing in the highest court of the land that an act of parliament enacted by the people's representative to fight corruption is unconstitutional. It is in the minority's view an act of constitutional betrayal without precedent in the constitutional history of the Fourth Republic. Even more troubling, on 27 January 2026, the Supreme Court dismissed the OSP's application to join the case as a party. The very application that would have allowed the institution to defend its mandate in the proceedings that sought to destroy it. The minority notes that this application was dismissed on the Attorney General's opposition. The AG did not merely fail to defend the OSP, he actively prevented the OSP from defending himself. Now the fourth weapon. On 15th April 2026, a week after the Attorney General filed his Supreme Court submissions, the government constitutional attack on the OSP was made fully public. In a high court in Accra, presided over by Justice John Eugene Nyadu Nyante, on a quo warranto application by one Peter Archibald Hyde, the judge ruled that the OSP has no constitutional mandate to initiate criminal prosecutions and declared all ongoing OSP prosecutions null and void, and directed the Attorney General to take over all cases and awarded costs of 15,000 Ghana